Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Enticement Lawyer, Chicago, Illinois. Being accused of enticement in Chicago, Illinois is an extremely serious situation with life-altering consequences. Enticement offenses involve allegations of attempting to engage a minor in sexual activity, often through messages, online communication, or even just broaching the subject. Illinois prosecutors treat these cases with zero tolerance. Even a conversation that never leads to physical contact can result in felony charges, steep fines, mandatory sex offender registration, and years, or even decades, in prison. If you're facing enticement charges in Chicago, you need to understand that the stakes couldn't be higher. A conviction can permanently damage your reputation, career, and personal life. The experienced criminal defense attorneys at Combs Waterkotte are prepared to step in immediately, analyze the details of your case, and begin building a strong defense strategy aimed at protecting your rights and your future. Call 3-125-OO-HELP today to get started. Enticement Lawyers in Chicago, Illinois, serving all of Cook County. An enticement charge in Chicago, Illinois is not something you can afford to take lightly. Prosecutors in Cook County aggressively pursue these cases, often pushing for the harshest penalties available, even when the allegations stem from online conversations or situations that never involved physical contact. Trying to handle these charges on your own can put your freedom, reputation, and future at serious risk. At Combs Waterkotte, we understand that enticement allegations don't always tell the full story. Misunderstandings, false accusations, and law enforcement sting operations can all play a role in these cases. That's why we begin every case with a thorough, confidential consultation to hear your side and evaluate the evidence being used against you. From there, our experienced team gets to work building a strategic defense tailored to your situation. We dig into digital communications, challenge how evidence was obtained, and identify weaknesses in the prosecution's case. Whether negotiating to reduce or dismiss charges or preparing for trial, we approach every case with the same level of urgency and attention to detail. If you're facing enticement charges in Chicago or anywhere in Cook County, don't wait to get legal help. The sooner you involve an experienced defense team, the better your chances of protecting your rights and your future. Call Combs Waterkotte today at 3-125-OO-HELP or reach out online to get started. What is enticement in Chicago, Illinois? While Illinois criminal law doesn't have a single statute called enticement, the criminal code does have a few different laws that essentially cover what other states would call enticement or child solicitation. There are essentially three statutes of interest: luring a minor, 720 IBARE LCS 5/10-5.1; indecent solicitation of a child, 720 ILCS 5/11-6; solicitation to meet a child, 720 ILCS 5/11-6.6. Each statute covers a specific kind of behavior. While the conduct involved in each law is similar, there are some important differences to understand. Luring a minor charges in Chicago, Illinois. Illinois' luring a minor statute covers some pertinent definitions that explain the terms and individuals involved in the offense. These definitions are luring, any knowing attempt to solicit, entice, or tempt a minor. Minor, a person who is under the age of 15 years old. Stranger, a person who does not know or associate with the parents of a minor. Unlawful purpose, any attempt to violate an Illinois misdemeanor or felony, a federal law, or laws of other states. Emergency situation, when a minor is threatened with immediate bodily, emotional, or psychological harm. Express consent, oral or written communication that is clear and unambiguous. Electronic communication, any contact through the internet or text messaging. With these definitions in mind, it's much easier to understand what constitutes luring a minor under Illinois law. The statute says that someone may be charged with luring a minor when they are 21 years of age or older, and they communicate to a minor electronically, knowing that the minor is under 15 years old, with the intent to lure the minor away from their home and parents, with an unlawful purpose in mind, without express consent from the minor's parents, with the intent to avoid getting express consent from the minor's parents, is a stranger to the parents of the minor. The statute does cover a couple of instances where an offender may not be in violation of the statute. For example, if they have a reasonable belief that the minor is over 15 years old, that may serve as an affirmative defense. An offender may also be acting lawfully if they are assisting a minor in an emergency situation. Indecent solicitation of a child charges in Chicago, Illinois. Illinois's indecent solicitation of a child statute also has a couple of important definitions to understand. These definitions include solicit, to command, authorize, urge, or request another to perform an act in person, over the phone, in writing, or via internet or text messaging. Child, a person under the age of 17. From there, the statute goes on to mention that an individual over the age of 17 can be charged with indecent solicitation of a child, or someone they legitimately believe to be a child, when they contact a child with the intent to commit aggravated criminal sexual assault. Criminal sexual assault. Predatory criminal sexual assault of a child. Aggravated criminal sexual abuse. That's not all, though. The statute even covers instances where an individual discusses an act of sexual conduct or sexual penetration with a child. In other words, a person can be charged even for talking about sex acts with a minor. They don't even need to meet with the child or commit the alleged acts. Solicitation to meet a child. Charges in Chicago, Illinois. According to Illinois' solicitation to meet a child statute, a person can be charged with solicitation to meet a child when they use a computer, cell phone, or other device and engage or solicit a minor, or someone they believe to be a minor, and does so without the knowledge of the minor's parents. For the charge to apply, the individual must do so with the intent to break an Illinois law. A person can be charged regardless of the law they intend to break. But, in most cases, the law in question is typically a sex crime in these kinds of cases. What are the penalties for enticement in Chicago, Illinois? Under Illinois criminal law, the penalties for child enticement-related offenses range anywhere from a high-level misdemeanor to a high-level felony charge, depending on the circumstances of the case. Each of the statutes listed above carry different penalties, depending on the severity of the violation. Luring a minor is typically charged as a Class 4 felony in Illinois, a conviction for which carries a possible prison sentence between 1 to 6 years, though first-time offenders between 18 and 21 will face a Class B misdemeanor charge. There are some instances, though, where an individual may be charged with a higher-level felony. The offense is a Class 2 felony if the defendant has a prior sex crime conviction. A second luring a minor offense results in a Class 3 felony charge. Second-time offenders with a prior sex crime conviction face a Class 1 felony charge. A third luring a minor offense results in a Class 1 felony charge. Third-time offenders with a prior sex crime conviction face a Class 10 felony charge. Anyone charged with luring a minor must also undergo a sex offender evaluation. The standard charge for indecent solicitation of a child in Illinois is a Class 4 felony as well. But there are certain enhancements based on what offense the defendant intended to commit. Indecent solicitation of a child is a Class 1 felony if the intended act would have amounted to predatory criminal sexual assault of a minor or aggravated criminal sexual assault. Indecent solicitation of a child is a Class 2 felony if the intended act would have amounted to criminal sexual assault. Indecent solicitation of a child is a Class 3 felony if the intended act would have amounted to aggravated criminal sexual abuse. Solicitation to meet child is typically charged as a Class A misdemeanor in Chicago and Cook County. However, if the individual believes they are 5 years or older than the child with whom they intend to meet, they will be charged with a Class 4 felony. Do I have to register as a sex offender for an enticement conviction in Chicago? In almost every case, a conviction for a child enticement offense in Chicago and Cook County necessitates registering as a sex offender in Illinois. Illinois Statute 730-OILCS-15-0/2 covers who must register based on the offense for which they were convicted. This is what the law requires for enticement charges. Luring a minor. Conviction automatically triggers requirement to register as a sex offender. Individual must stay registered for 10 years and possibly for life for repeat offenses. Indecent solicitation of a child. Registration is required even if the offense was via verbal or written communication only. Individual must typically stay registered for 10 years. Lifetime registration is possible for severe offenses, like attempting to commit predatory criminal sexual assault of a minor, or repeated offenses. Solicitation to meet a child. A misdemeanor conviction does not require sex offender registration. A felony conviction does require sex offender registration. Criminal defense strategies against Chicago enticement charges. While Chicago and Cook County prosecutors pursue convictions in enticement cases aggressively, a good defense lawyer can still make a huge difference. At Combs Waterkotte, we've successfully defended Chicago residents against enticement charges before. We've found the following criminal defense strategies to be especially effective in getting enticement charges reduced or dismissed. Reasonable belief of age. In some Chicago enticement cases, a defense may focus on the defendant's reasonable belief that the alleged victim was of legal age. While Illinois law often limits this defense, it can still be relevant in Cook County cases involving online communication, fake profiles, or undercover operations. Defense attorneys may present evidence like messages, profile information, or representations made by the alleged minor to show that the defendant had a reasonable belief that the minor was of legal age. Lack of intent. In many Chicago enticement cases, the prosecution must prove the defendant intended to persuade or solicit a minor for unlawful sexual activity. A strong defense may focus on the absence of that intent, particularly in ambiguous online conversations. In Cook County courts, defense attorneys often argue that messages were misinterpreted, taken out of context, or lacked any genuine criminal purpose. Without clear intent, prosecutors may struggle to secure a conviction. Entrapment. Entrapment is a common defense in Chicago enticement cases involving undercover officers. If law enforcement induced someone to commit an offense they were not otherwise going to commit, the charges may not stand. This defense focuses on whether the idea originated with police and whether the defendant was pressured or persuaded into illegal conduct. Courts closely examine chat transcripts and officer conduct in these situations. Fourth Amendment violations. Many enticement cases in Chicago and Cook County rely heavily on digital evidence like texts, emails, and social media messages. If law enforcement obtained this evidence through an unlawful search or seizure, it may be suppressed. A Fourth Amendment defense challenges warrants, subpoenas, and digital privacy violations. If key evidence is excluded, the prosecution's case can weaken significantly or collapse entirely. Fifth Amendment violations. Statements made during police questioning often play a major role in enticement prosecutions. In Chicago and throughout Cook County, a defense attorney may argue that a defendant's Fifth Amendment rights were violated if they were coerced into making incriminating statements. If law enforcement failed to respect the right to remain silent, those statements may be excluded from evidence, limiting the prosecution's ability to prove guilt. Miranda rights violations. Closely related to Fifth Amendment protections, Miranda violations occur when Chicago police fail to inform a suspect of their rights before custodial interrogation. In enticement cases, this can be especially important when defendants make damaging admissions during questioning. Cook County courts may suppress these statements if proper warnings were not given, which can significantly impact the strength of the prosecution's case. Mistaken identity. In online enticement cases, identifying the actual person behind a username or device is not always straightforward. A mistaken identity defense may argue that someone else used the defendant's phone, computer, or account. In Chicago and Cook County, this defense can be particularly effective when multiple users had access to the same device, or when digital forensic evidence is inconclusive. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.